We welcome one and all to this afternoon session. For this afternoon session, our resource person is Mr.M.RamJawahar sir, will have an introduction. He is an Assistant Controller of Patents and Design in the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India since 2003. He has examined and granted more than 15,000 new inventions. He is a mechanical engineer, obtained his ME in Internal Combustion Engineering from College of Engineering, Anna University, Guindy, and MTech in Polymer Science and Engineering from College of Engineering, Anna University, Guindy. He has more than 4 years of teaching experience in the Department of Mechanical Engineering. He obtained general course on intellectual property rights, Geneva, copyrights and related rights, electronic commerce and intellectual property, advanced course in patent information search from WIPO, Geneva. He also obtained his PG diploma in IPR. He has been to Japan for 3 months to study the procedures and system practiced at Japan Patent Office. He has also obtained a certificate course in German language from University of Madras. I now request our Director Madam, Dr. Umarani Madam, to present Sir with a bouquet and a book. Please accept this, sir. As a token of love and appreciation, we would now present a bouquet and a book. Thank you, madam. Thank you, sir. Over to you, sir.
Thank you very much for this wonderful opportunity given. Intellectual property rights. Hope many people know this topic before. How many of them heard of this topic? Everybody. Nearly around 75% people know about what is intellectual property rights. So many people, for them the topic is very new, but it's not a new topic. This concept introduced way back, more than 100 years old concept. So what I'm going to concentrate today's topic is whether this particular thing is important. Is it a need to know about these things or not? Those things we will concentrate. Okay. What is intellectual property? So intellectual property, in the sense, it's a creation of intellect in industrial, scientific, literary and artistic field. For example, if you are buying a land, what you do? You go to sub-register office and register your land. Then you go to revenue department and get a patta. After that, the property belongs to you. Even after that, what happens? Sometimes some may occupy your land, then you go to court, and there is so many problems. That is visible properties. These are all the wealth like invisible things. So think about that. If someone is stole your prop, what you will do? It needs the previously what happens, if somebody invents something, the people call them, just honor the person, that's all. Is it enough for an inventor? No. So for that reason, there is a phenomena to respect the people in the form of giving royalty, the intellectual property, this concept introduced, right? The previously, nearly around 2004, I joined this office, 2000, and nearly around 18 years I am working in this office. I have examined and granted around 15,000 patent applications. So when we joined, nearly around 20% of applicants are Indian applicants, 80% applicants I met are foreign applicants. So most of the applicants, they come for the hearing is Japanese applicants, Korean applicants, European applicants, US applicants. But the trend has even I think in the year 2017, there is a small change this percentage. That is 2 weeks back. What the report says is, Indian filing rate is slightly overtakes foreign filing rate. The previously no such thing was there. What is the reason? Do you think what is the reason why very less Indian filing rate? What's the reason? Can you guess? Do you mean to say that there is no inventions in India? Then lack of awareness. Many people think that what is the use of patents? What is the use of trade? There is no use. So that mentality was there. But slowly that thing has changed. That's what I think you people know about the story of the Kodak and Polaroid. What is Kodak? Kodak, Polaroid, both are in the field of camera. The Kodak people have invented beautiful technology, and many people advised Kodak to file a patent. They said there is no use of patent, why to give so much importance to patent? Like that they have not given much importance to patent. So after some time what happened, Polaroid somehow know about the invention, they filed the patent first. And very next day what they did, the property belongs to us, Kodak copied. So after that it goes to the court, and what the court given, unfortunately Kodak couldn't succeed in this particular case. Okay, it was very difficult for Kodak to prove, or Kodak finally could not succeed. Now the company called Kodak exists or not? That's the biggest question mark. So that is the importance of patents. Okay, we may think that there is no use of patent, but in the coming years, the concept of patent is very, very important. Okay, intellectual property rights, it has many divisions like industrial property rights and copyrights and related rights. Previously the copyrights and related rights, this was with HR ministry. But now everything under our ministry, Commerce and Industry Ministry. So we people are taking care of patents, designs, trademarks, geographical indications, semiconductor rights, and all these things, and copyrights and related rights. These things are comes under intellectual property rights under our ministry, right? So it's not the new concept, it's a very old concept. I think I am not going deep into the economics, but just to brush up what is the importance of these concepts. Can anyone know about what is GATT? General Agreement on Tariff and Trade. Okay, General Agreement on Tariff and Trade. Of course, it's right. In 1948, the General Agreement on Tariff and Trade was introduced, and after that, what happens? There is no dispute settlement body in GATT. There is no dispute settlement body in GATT, and then WTO introduced. What is WTO? World Trade Organization. What is the difference between GATT and WTO? GATT ku WTO ku enna difference irukku? GATT converted into WTO. There is no difference. Up to 1994 it was only GATT, and from 1st Jan 1995 onwards that becomes WTO, World Trade Organization. India became the member of WTO 1st Jan 1995. Okay. So when we become the member of WTO, there is so much of criticism. Why India? India is a developing country. Is it possible to compete with the developed nations? There are so many criticisms. India not supposed to become a member of WTO. There is so many things happen. But it's a duty of government of India to justify why India became the member of WTO. What they say is that 93% of global business is under single roof. So every country under single roof. If we are not becoming the member of WTO, then what will happen? You are not becoming the member of WTO, then India will be isolated. So this is one of the reason. And one more reason is it says that many people says that 3% of compulsory import in WTO. These are all the reasons why India became the 3% of compulsory import, they said. But actually India's import is more than, in some sectors it is 30%, 40%, 50%. That factor does not affect. Many people say it's that patented seeds and medicinal prices will go up high. This is not the case. It depends on the export and import. So these are the justifications government of India given, and India became the member of WTO. The main thing is wealth creation, free and fair trade, and tariff barriers are there. So when we become the member of WTO, so the tariff barrier, non-tariff barrier, production subsidy, and all those things, I am not going deep into these things, but just I am giving a glimpse why the patent concept has arisen. The WTO and agriculture. So after we became the member of WTO, the people talked about subsidy. So domestic support. India is a country of agriculture based country. We need to protect our farmer also. So amber box subsidy. What is amber box subsidy? Subsidy in the sense, for example, ration. Ration we are giving subsidy. We have a green card, and recently for 1,000 rupees will be given for the ladies, and free rice. All these things are all comes under these subsidies only. What WTO says is, you stop all the subsidies. Stop all the subsidies, because we already became the member of WTO. So we have to follow the guidelines of WTO. What WTO says? Stop all the subsidies. And this is amber box subsidy. Then how India justified? There is one more subsidy in WTO. It says that a green box subsidy. What is this green box subsidy? For example, in US they are giving subsidy in the form of green box subsidy. For example, the Tesla is inventing some car or something else, means for research they are giving subsidy. 20% subsidy given for research. So what Government of India stand is, stop green box subsidy, then we will stop amber box subsidy. So still this thing is not settled. That's the reason why still our subsidy is continuous. Then blue box subsidy. It's a restriction. Restriction in amber box subsidy is blue box subsidy. And one more concept called TRIMS, trade related investment measure. What is this TRIMS? I think in the newspaper you might have read that concept called what is that? Bullionism. What is bullionism? In the sense, the gold standards. It's a gold standards. And one more concept is called MIGA, Multilateral Investment Guarantee Agency. What is this is the thing, like for example, the foreign company comes to India. They are doing some business, and suddenly something like in Sterlite, what happens? Suddenly the company closed. The company has invested so much of money, but some other reasons it is closed. So if you are a member of MIGA, then the insurance will be covered. Whatever the amount they lose, okay, that amount they will get through MIGA, Multilateral Investment Guarantee Agency, because these people are the members of MIGA. So these are all some concepts are there. Then WIPO. Have you heard about WIPO? What is WIPO? World Intellectual Property Organization. Okay. Even though we are working under Ministry of Commerce and Industry, our ultimate boss, the WIPO, is giving guidelines in the form of the things called TRIPS, trade related intellectual properties, the guidelines, how the intellectual property rights to be framed, how to implement, how to enforce, all these things were covered in TRIPS. Okay. World Intellectual Property, do you know where is the head office WIPO? Geneva. Okay. Then of course, to protect our people, there is a concept called, the Government of India is making so many concepts like FDI, MIGA, we are already under WIPO and TRIPS, the guidelines given for us. And one more thing, the best concept is BRICS. The BRICS concept, what is BRICS? I think you people know about what is BRICS. The Brazil, Russia, then South Africa. So these are all the countries, because these are all the developing countries. When the concept comes, the developed countries and developing countries, okay, they compete with these. All these countries are developing countries. They have a separate bank, so no need to go to World Bank. So this has enough money. We can get a loan from these banks. So to govern all these things, there are so many concepts are there. I am not going deep into all these concepts, just giving some introduction about this concept. Okay, what is the main advantages? Intellectual property rights. What's the main advantages? Main thing is duplication of research. Main thing is duplication of research. What is this duplication of research? Duplication of research in the sense, so 10 years back, some students from some private college, they come to me and, sir, I want to file a patent for particular things. That's a beautiful concept. We agreed the concept and we given some guidelines how to file a patent and all those things we have given. After a month time, another college students came, they come with the same work. They come with the same work. So, after that in IIT also they have done some research and all those things. Then what they concluded is nearly around 30 to 40% of BE project work are repetition. So, this is the biggest enemy. The duplication of research is the biggest enemy for the country's growth. Okay. So, some people, previously the 4-5 years I am working here only in a mechanical department, I was working here. That time we used to go to other colleges. So, that time in some colleges also some students explaining about some project work. When we go to other college, same concept was explained by the students. So, I never say that these students are copied. They are not done the proper literature survey. So, literature survey is very, very important. And finally, one day I met one person, he is having some company near Avadi. And he says that, sir, I am making so much of money. Most of the BE students approaching me. BE project work is 5,000, ME project work is 8,000 and PhD project work is equal to 3 ME project work. So, why I am saying all this, don't follow this, that person is making so much of money. Don't follow this type of shortcut technology. Whatever you do your own research. So, once 10 years back I gone to the systems practiced in Tokyo, how the Japanese, these things, we go to some of the universities. That time what we understood that the people never worried about S grade or A grade. They want to do some beautiful project work. They want to contribute something to the nation. They never worried about S grade or A grade. But when I interacted with our students, their mentality differs. First they concentrate on S grade or A grade. That mentality you should change. So, the country like Japan, there is no resources, absolutely no resources. What is the strength of Japan? Only thing is technology. Except technology, there is no, but as compared to Japan, India is having so much of resources. Resources is more, but technology is less. Okay. So, what they are doing? They are just importing bauxite from Australia, then making a beautiful product, aluminium, and send it back to Australia, and they are making huge profit. But here, for example, I always used to say, India is a country has second largest thorium deposits. If you go to the Bay of Bengal coast or Andaman coast or Arabian coast, even our sand has thorium is an excellent alternative to uranium. But unfortunately, we don't have the technology to separate. So, what we are doing, Sammo and the Manal Kartala, in any name, it goes to other countries, then what will happen? It will come back to India. For uranium, such a huge price we are paying and buying. So, when we improve our technology, if you have the technology, automatically our economy will grow, our growth will definitely improve. That is the reason why Government of India is giving so much of importance to technology. So, they are giving so much of money in science. There is a department like science and technology, they are, whatever the project works, they are ready to give money for your research works. When I was talking with, once I talked with the entrepreneurship development cell director, sir, I have enough money. But people are not approaching. Even for filing these research activities or patent activities and all those things, not only government of India, even government of Tamil Nadu also giving so much of money, and people are not approaching. At the end of the year, I mean in the financial year March, they are returning back the money to the government, then next year. So these type of things, the opportunities we are not utilizing. So abreast and latest development in different fields of technology. For example, in our days, 6 months we do literature survey. We go to library and see the journals, 6 months. But now it is not the case. If you go to Google, just one click, you will get all the informations. In 1 month time, you can complete your literature survey. In our days, 6 months to 1 year we did. Helps the industry to improve on existing technology and produce and cheaper and better products, serves as an indicator of achievement in R&D institutions, R&D, research and development. So I visited some of the industries. What the standard says that 30% of their income we should spend for research activities. But whether our companies are having the proper R&D or not, that's a question mark. Again, one day I interacted with one company, beautiful company, they have a R&D. Sir, what are the products you have developed? There are so many things I asked, and finally he said, if I am having R&D, I can get the tax benefits, sir. That is the reason why we have. So that mentality, these are all our drawbacks. If you change our mentality, definitely more inventions will come, automatically our economy will improve, right? So, thing is, they encourage the inventors. To encourage the inventors, work in the patent and inventions on commercial scale. Your mentality, if suppose, I want to invent something, what mentality in your mind is, I want to publish this one in IEEE journal or SAE journal or 2 international publications and 2 local Indian publications, that's enough. That mentality is there. But you must change that mentality. You go for patent and make money. Okay, what's the difference between these research publications and patent is, once you get a patent and someone else is using your inventions or something like that, means issue a notice and definitely you will get a royalty. Okay, there are many small scale, I mean, recently the government of India is giving so much importance to startup companies. I met the startup people, many people I met, and they were doing some beautiful work and beautiful, all these things, they are making some profits. And after 3 years time, they received the notice, some unknown person says that what are all the products so far you produced, I already got patent for the particular thing. Like that they received the notice. Then they come to me, sir, what happened, sir? This type of, yes, patent is there. You need to give a royalty to him. So those people, they never know the importance of patents. Once they receive the notice, and so far for the 3-4 years, how much amount they earned? Nearly around 75% of money they lose. Okay, so that's the importance of patents. So what are the anticipations? Okay, I already done some beautiful research work, and some people they publish the document. If you publish the document in the journal, once you publish the document in the journal, then you come to the patent office, then your own invention will become your enemy. We cite your own invention. Okay, that is the reason why the sections are introduced. Section 29 to 34 introduce what it says, that even though you published your own invention in some journal, within 1 year time, if you come to patent office, then we don't cite your own invention as the citation. Okay, within 1 year time, you keep it in mind. And communication to the government for investigation. What some people do is, they do a beautiful research work immediately when former President Abdul Kalam, in his period, many people, they don't come to patent or they don't publish research paper, they directly write their invention and send it to President. And he sees every invention, and in his own handwriting, he writes and send it back to us. This inventor has wrote, it's a beautiful invention, but wrote all the invention in Tamil. You people help him to write it in English and ask him to file a patent. See, this is like communication to government for investigation. That is not the citation. Or if you go to some exhibition, you display your invention, that also within 12 months time, you come to patent office and file a patent, else your own invention will become your enemy. Okay, public working. If suppose you are testing your product, within 12 months time you come, then it's not the citation. And something, you are doing some research work, you know that I will get a result within 10 months time, but I don't know the exact value, but definitely I will get these results. So between this 10 months time, someone else files a patent, then they will ask royalty from you. In this scenario, there is a thing called a provisional application. So provisional application, without claims, you file a patent. Then within 12 months time, you file the 6 months, then another 6 months you can ask. So within this time, if you file a complete specification, then your priority starts from first filing date of provisional application. Okay, that is the reason why provisional application, provisional specification concept introduced. Okay, today you are filing a patent in India, and you think that my patent has value in other countries. So within 12 months time, you go to Europe or you go to US, you go to Korea, any country you can go and quote this priority date. So the European examiner, like me, the Europe also, European examiner and US examiner, they don't cite any documents, because your first filing date in India, that counts. So within 12 months time, you can file the application in other countries. That is called convention application. Then one more application is called a PCT application, Patent Cooperation Treaty. What is this Patent Cooperation Treaty? Already we have become a member of WIPO. Under WIPO, there are 152 countries are there. Once you file a patent in India, then within a year time, you file an international application, we will forward your application to WIPO, and WIPO will forward your application to all the 152 countries. So those countries will contact you. You give reply to, you can select the countries. You can select the countries and give the reply. This timeline is 31 months from first filing date in India, right? Then the priority starts from first filing date in India, right? So these things are considered as not anticipation, right? So what is patentable? Patentable, any inventions. Inventions which has novelty, inventive step and industrial applicability. These three things are very, very important. This is a section 2 and section 3 and 4. And section 2 is 21J, novelty. Novelty means if suppose you are filing a patent, as such a same concept available or some document is exactly available, means we cite the same document. We cite the same document. Then in this scenario, you will not get the patent because you are copied. And the second thing is inventive step. What is this inventive step concept? For example, what some people will do, you take one portion from one invention, document 1, other portion from other invention, other portion from 3 documents, and you couple together and make a new invention means, so we cite 3 documents, document 1, document 2 and document 3. So this fails under inventive step, and definitely it should have industrial applicability. Definitely it should have industrial applicability. So this is a section 2 of Indian Patent Act. What is section 3 of Indian Patent Act says is, you keep it in mind, inventions frivolous and contrary to well established natural laws. Any invention, if it is contrary to well established natural laws, that is not patentable. What is this well established natural laws? For example, the thermodynamics law. The second law of thermodynamics says that if the output is more than input, it's not at all possible. I know that this lathe machine can give only 45 to 55% of efficiency. If someone says that this machine is giving 90% efficiency, then the biggest question will come. I met one inventor, he made one beautiful invention, if a train is moving, for starting the engine using the diesel, the engine is moving. So after some time, he stopped the supply of diesel, he fixed the small flywheel at the top of the engine and every compartment. After our time, he stops the supply of diesel, then using this wind energy, he runs the train. He asked for patents. Can you give the patent or not? Is it possible? Yes or no? Why no? Sorry? Yeah, he is exactly right, because that energy required to drive a train, it's not that wind energy. Using this wind energy, what you can do? Just inside one fan or one light inside the compartment, that is possible. Not to move the entire train. Okay, not to move that energy is not sufficient. So that is not patentable. Okay, it is against the, we can say that against the Kelvin-Planck statement. Okay, against clashes in inequality. Okay. So frivolous and contrary to well established natural laws. Best example for this one is perpetual motion. Continuously, is there any perpetual motion there? If someone says that perpetual motion means definitely not possible. Okay, perpetual motion giving output without input, it's not possible. Based on this, we met one inventor, that is, I think you heard about that person, that Mooligai petrols. He come to Anna University also, he has demonstrated, and he come to patent office, he filed the patent, and we raised so many questions, and that time the 12 months time, after first FIR report, from first examination report, we given 12 months time for him to give a reply, but he didn't give any reply within 12 months time, then his patent refused. That's one of the objections, sir. How he is getting that much energy? Without input, you will not get output. And invention contrary to law, morality and injurious to public health. Any invention, law, morality and injurious to public health. If you are making some invention, how to mix a brick powder with masala powder, கண்டுபிடிக்கவே முடியாது. இத மாதிரி இருந்தா, so we object this type of invention in section 3B. One inventor, he come to our office and says that he made one beautiful belt with so many sensors. What he says is, if a pregnant woman wears that belt, the belt will say that two lights, red, green and yellow. If this light blinks, it's a boy baby. If this light blinks, it's a girl baby. No need to go to gynecologist. That's a beautiful invention, but we cannot grant it because this is against government law. But he can get a patent in other countries. In US or Australia, it's allowed, but here it's against the law. So contrary to law, morality and injurious to public health. Once you find out something, don't wait. Immediately go and file a patent. If I ask you the question, who is the inventor of telephone? Alexander Graham Bell. Yes, Alexander Graham Bell. So what happened in US patent office? Alexander Graham Bell reached in the morning. The same day afternoon, Eliza Gray, he reached. But nobody knows about who is Eliza Gray. He never copied. He stayed in some city. This man stayed in some other city. Because of some traffic jam, this person reached the office in the afternoon. That's all. If he could have reached in the office in the morning, nobody knows about who is Graham. Well, there is so many confusions in the inventions. If you talk about invention, there are so many beautiful stories are there. Like if I ask you the question, who is the inventor of radio? Radio yaar kandupidicha enakke marandiruchu. Marconi. Okay, Marconi who invented radio. So after that what happened in the year I think 1938 he died, and 1942 Tesla died. So after 6 months after death of Tesla, the Supreme Court declared that what are all the inventions that Marconi made, it's not his property, it's actually Tesla property. But still our textbook says that who is the inventor means Marconi. So, and in between some other person says that sir I demonstrate, but Supreme Court said that even this happened after death of Tesla. And discovery of scientific and formulation of abstract theory, the mathematical modeling. Just a mathematical modeling is not patentable, just you are doing some modeling work. Mathematical these things is not patentable. And discovery of the new use of known substance, process and machines. New, for example, aspirin which cures cardiovascular, the same composition may cure some other disease. So each use is not patentable. This is the most important law, though no country has this law. Only country has 3D, section 3D is Government of India. I think in the newspaper you might have studied that Novartis case. Novartis, that is a cancer drug. Novartis is they found out some cancer drug, they got a patent all over the world. Then they approached India. Our people refused. Then the lawyer represented, that famous lawyer represented for that particular case, and after that what happened, they go to IPAB, Intellectual Property Appellate Board. There also they given decision in favor of us, and they go to High Court, then Supreme Court. Finally we won the case. Only country not granted is India. Other countries they granted patent for this because it is called, the concept called evergreening patent. For example, that lifetime of patent is 20 years. At the end of 18th year, made one small composition change and they file a patent, they will get another 20 years. This is called the evergreening of patent. Okay, that's the reason why the people not granted the patent for the particular thing. This section 3D. And then the composition obtained by the admixture and its preparation process. If you are mixing 2-3 things and you are not getting any proper output, just like that mixing something, no remarkable effect means it's not patentable. And mere arrangement and rearrangement of known devices. The famous example people always used to say that umbrella fitted with fan and bucket. If you have an umbrella, then you fix a fan, just lift the umbrella, then put a switch and fan will rotate. It's not patentable. In bucket fitted with torch. Sir, if you are saying all these things are, everything is not patentable, then which one is patentable? The main difference is if you are driving a car. The previously in ambassador cars, if you put a right indicator, what will happen? Indicator light will blinks. And you make your steering straightens, even then indicator blinks. But it is not the case. Now if you make your steering straightens, automatically your indicator comes to rest. So this one is patentable because some coupling mechanism, the inside some connectivity is there. The previous one is not patentable. Okay, previous one is not patentable. And like that, have you noticed that the wiper in your car, the previously when you put during that rainy season, put your wiper, what will happen? Wiper cleans your windshield. Once you switch off the wiper, what happens? It stops there itself previously. Now can you notice that when you switch off the wiper, then again 2 rotations it comes, then it comes to rest. What is the mechanism involved? That's a beautiful mechanism, but actually speaking, this concept not comes from big R&D. Even ordinary mechanic found this technology. But the company made good money out of this invention. Then once that person has asked the company board of directors, then they say that before joining this company, this agreement you have signed, what are all the inventions you done using our property, it belongs to us. Okay, you cannot claim anything like that. See, same type, this type of thing, this happened in Japan. One inventor called, I think you heard about this case, inventor called, his name is Nakamura. He worked in the company called Nichia. In that Nichia company, he is a person first, he invented blue LED. Okay. And finally, the company made so much of money. And this person, but the inventor is ordinary worker. And company given 20,000 yen. How much is 20,000 yen means in Indian rupee it is something around 10,000 rupees. 20,000 yen. It's nothing. And finally that person approached the court. What the court says, before joining the office, what are all the properties? Using our, then this thing, the invention belongs to us, like that the company said. And court has given the beautiful judgment, even though you have such an agreement, but what the inventor contributes is much more. So you need to give us such a good compensation. So he given such a beautiful compensation, and very next day he resigns the job. Now the inventor settled in US. So even though the agreement is there, the judgment comes like that. And plants, animals and GMO. Genetically, so if you say that genetically, nowadays there is many inventions comes in GMO, and gene related inventions are coming. So one invention I read, very interesting invention, that is called one company called Myriad. That company, they got the patent for one invention called the presence of BRCA1 and BRCA2 gene in our body. Presence of unga body la BRCA1 and BRCA2 gene irukanu kandupidikira technology. That is their invention. Okay. So this BRCA1 and BRCA2 gene present in the ladies, I mean mainly this test is conducted for ladies only. If a lady has BRCA1 and BRCA2 gene, then 100% chance of getting breast cancer. That is the invention. It's got granted. And the invention, the testing cost alone is $4,000. How much? $4,000. It's such a huge money. Such a huge money. In US, if you go there, everything is under medical insurance covered, all treatment. But testing procedure is not covered. And what happened one day, do you know Angelina Jolie? Yeah, Angelina Jolie, actress. She opted for this test, but unfortunately the test result says that she has BRCA1 and BRCA2 gene. 100% chance of getting. Then she consulted many doctors and finally she opted for double mastectomy. Then after that she wrote her experience in the book. The book is large selling book, and after reading that book, most of the US ladies, they stood in the queue to do that particular test. And that time the Obama, he changed that this called Obama Care Act. So everything is covered under medical insurance, but testing procedure not covered. But all the US ladies stood in the queue, and immediately that also included in the medical insurance. That time itself, that was $4,000 US. The company made such a huge money because of this presence of BRCA1 and BRCA2 gene in the body. So this gene technology, there are so many inventions coming, and people are making so much of money. And method of agriculture and horticulture, the cultivation of algae. If someone says that in this manner, if you do that agriculture activity, you will get a more output, mean that we don't give patent for those things, right? And the process of treatment of human beings, if a doctor says that in this way, if you do the bypass surgery, 100% chance of success, those things, the composition, the tablet composition, we are giving patents, but treatment procedure, it's subjected under section 3I of Indian Patent Act. Okay. And mathematical business methods, and this one is previously this law was there, the mathematical business methods and computer program. As such, computer programs are not patentable, but recently the CRI guidelines were introduced in 2016 and 2017 for computer related inventions. Whenever the software, if you make some software program, if a software coupled with the hardware, then it is patentable. So as such software, you please don't come with as such software programs. Whenever the software coupled with hardware, it is definitely patentable. You may ask the questions. Nowadays, if you go to CTS or Infosys or TCS, every software office has intellectual IPR cell. If a programs are not patentable, what for these companies has IPR cell? But as per Indian Patent Act, pure software programs are not patentable. But US Patent Act, even software programs are patentable. So what they do is, they come up with the program. As an Indian citizen, they cannot directly file a patent in other country. If you want to file a patent in other country direct, you need to get permission from Indian Patent Office. So these software companies, they come to our office, they get a permission, they ask for a permission. Within 15 days time, we give permission. So after that, they take their invention and they can file a patent in US or other countries. So literary, artistic, dramatic creations include hologram works and television productions. These things are not patentable, but these things are covered under copyright. So there is huge difference. The copyright is nothing but if you are writing a book, writing some stories, and those things are covered under copyright. So the lifetime of the copyright is completely different from patent. The patent, it is only 20 years, but copyright, after death of author, it is 60 years. That's why whenever I talk about copyright, immediately the people ask the question that what happened to SPB and Ilayaraja, those things, he performed his music in US. So whenever these things, so in between the producer came, I already given money to both lyrics writer and performer and music director, the property belongs to me. And if nothing, no agreement is made, then the ratio 5:3:2, the benefit will, they share their benefits. Okay. So today's world, whoever makes, even all music directors, they have a separate agreement and says that even though you pay money, that property rights always with music director, like that they have a separate agreement. And mere scheme, rule and method of performing mental act and method of playing game. In this way, if you play chess or cricket, you can score more runs. that the cricketer cannot get a patent. And any inventions, if you are using the related to compounds, uranium, thorium, and these things means we will grant patent, and before that what we do is we refer your application to BARC, or anything related to weapons means then DRDO. Once we get the clearance from DRDO BARC, then proceed for, your application will proceed for grant. Okay, how much time left, madam? Sorry, still, okay, I have enough time. So, license and permission granted by the IP owner to the another person to use the IP agreed terms and conditions. This area is somewhat the untouched area. Licensing. Okay, technology transfer. I think you heard the term called technology transfer. The people make more money in this area. Technology transfer. Technology is available somewhere. Somewhere the requirement is there. There is no mediator there. So, person who is practicing this technology to this area, they are making good money. The term called technology transfer from the technology, Indian technology. For example, one invention, one person, he made one tumbler. Okay. For example, hiccup comes, what do you do? Vikkal vanchana enna பண்ணுவீங்க? தண்ணி குடிப்போம். ஓகே, இல்லை ஏதாவது some shocking news will, ஏதாவது ஒரு அதிர்ச்சியான டக்குன்னு ஸ்டாப் ஆகும். பட் சேம் திங், சப்போஸ் ஒரு விவேக் ஜோக்கில் கூட பார்த்துருப்பீங்க, விக்கல் வந்தோடனே இமீடியட்லி he calls the ambulance. Not in India, in Singapore. So, one inventor, he made one tumbler. Here one electrode is, at the end of the tumbler one electrode is there. If you take a water, then it will become a conductor. When you start drinking water, the electrode touches, here one nerve is there. When it touches here, automatically your hiccup comes to rest. This is one invention. If you make this type of tumbler and you sell it in India, nobody will, here nobody will buy. So, you transfer this technology to Singapore or other countries, the person who transferring the technology, he makes good money. Okay, there the requirement is there. So, the place of introducing your technology, you make so much of technology, but use your many people, they make very good technology, but use this technology to get the next promotion. And in the biodata they fill up, sir, I got patent. But the people not think about using my technology, I can make lot of money. The many, I seen good inventors, they never go to any job. They have 4 or 5 patents, that's all. They are getting royalty, good amount of royalty. No need to work. That mentality you need to change. And licensing creates income source. It establishes the legal framework for transfer of technology and wider group of researchers and engineers, creates market presence for the technology or trademark. I think trademark, many people ask the question, sir, what is the difference between trademark and the trademark is completely different from patent. What is trademark? It's just a emblem. For example, the Logitech, the style of writing this Logitech along with the emblem, that thing you can register. For example, this case, the trademark means immediately, that is the Talapagatte biryani. The previously, if you go to every road corner, you can see that yellow color board says that Talapai. Everybody is using that one. And the real owner, one day he approached the court and says that it is mine. Then very next day, the judgment came. What the judgment says? This is Dindikkal Talapa Katti, not Kattu. This is Chennai Router Talapa Kattu. These people, two things are different. Very next day, I think you might have noticed, all the people removed the board. That 10 years before, every road corner you can see that yellow color board talapakata. Now only the authorized people can use the So the authorized people can use the particular word. That is the importance of, but trademark the term is initially we give 10 years, then every 5 years it is renewable. There is no deadline for trademark. Every 5 years you can renew your rights. Okay. So before that, you do the proper search is determine the possibility of patent. So don't say that the search is very difficult. Determine the novelty and inventive step of invention, determine the prior art and plurality. Don't search in one database. You search in 2-3 databases, and for example, the database in the sense, the Google is a beautiful database. You go to Google and type USPTO, US Office website will open, and there you can give your keywords, the related inventions will come. Or another one more beautiful website is EPO, European Patent Office. These are all free only. Just give European EPO, that website will open. You can do the search in particular this thing, or JPO, Japanese Patent Office, and KIPO, Korean Patent Office. From here there are so many inventions are coming. So using this database, you can do the beautiful search whether the product is available or not. Okay. If you felt that all these things are tedious process, then just go to Google, type Google Patents. The Google Patents, the page will open. If you give the keywords, all related patents will display. Okay, helps to write our patent applications. So there, how to write a patent applications, the model patents, everything is available. Helps to understand the competition, avoid patent infringement, help to learn more about the field of invention. So this prior art search, money and drafting and filing the prosecution, and patent filing in the sense there is 2-3 forms are required. There is not much more forms. The form 1, it is about your invention, that is 1,750 rupees only, not more than that. And one form 18 is 4,400, and form 9 is, it's optional only. If you file form 9, within a month time that will be published in government gazette, otherwise it takes 18 months to publish in government gazette, that is 2750. Totally around, with form 3 and form 5, there is no fee, declaration of inventorship and foreign filing particulars. So totally about 8,900 rupees it will come, not more than that. And focus the specification can distinguish between the invention over the identified prior art to strengthen the case of patent. Identify the related ideas might inspire the ways to broaden the claims and speed up the patent grant. So understand the technology, the inventive features, market, so list down the main features, the how to do the proper search. For example, if suppose your invention is electronic chopping machine. When it is electronic chopping machine, so what are the keywords? List down the keywords. What are the keywords? Shape of the blade. You can do some modification in the shape of the blade. And the sharpness, that is other feature. And ease of handling and battery operating time. So these are all the 4 main things. Then sometimes that equivalent word may be there. For example, some country they may use COLOUR, some country use COLOR. So that synonyms, the equivalent words also you please use, and IPC, the classification. For example, in Chinese patent office, maybe the document may be available in Chinese language, but anyway the Google translator is there, but IPC is there, International Patent Classification. The classification is same for all over the world. If you give this particular number, the the invention is for this blade. Okay. For each and everything, there is an IPC classification is there, search query is there, and database is there, and types of search, the patentability or novelty search, freedom to operate, right to use search, validity or invalidity, enforcement ready search, and during infringement and license negotiations, and state of art. You do all the search, then you go for your production or whatever may be your research. Okay, that is very important. I met one inventor, he made one electric bicycle. What happens? He comes to patent office and files a patent, and tomorrow he told me that within a month time he is about to introduce that particular product. But what happened, unfortunately, one person, he introduced the product and he published the product. Okay, with one higher officials, I think somewhere it is happened. And he come to me and says that, sir, it's my product. This type of things has happened. But that person, the mistake he did is he didn't file the patent. But he filed the patent, not published. Once the problem comes to us, but that person not applied for a patent. And finally, I came to know that these two people are good friends. They work together. And some problem happens. So many people I met, even the BE research students, every day I am meeting BE research students, 4 or 5 people come and file a patent. Sir, we are all very good friends. Yes. Once the royalty or money comes into picture, and next day all the 4 people come and meet me separately and says that, sir, actually this is my idea, he has copied. And again next day this person and comments. Whenever the money comes, then no question of friendship. Okay, that is the reason why be careful all these technical aspects and how to protect your inventions. Okay, you take care of all these steps, state of art search and technology landscape analysis, and subject of title, abstract, clients. So this is that classification, international patent classification, ECLA, US classification, CPC. So this is that classification. These are all some search terms. I think in electrical engineering you might be OR gate, NOR gate, like that. This or this means both the things will come. Not means term A, not term B means only this term should come, other term shouldn't come. And means both the things. Search query term, how to do in the patent website. Using this ideology, you can do these are the Boolean operators. And adjacent means, so next 2-3 letters, maybe different spelling means it can take that. ADJN and near N. So within N terms of B and any order in the same sentence. That will search only in the sentence. A with the same sentence of B, A with same paragraph. Okay, same paragraph, that is different order it may be there. These are all the proximity. This itself is the biggest, the search itself is the biggest thing, like star, hyphen, monosaccharides. If you are searching for only the dollar symbol, then you search for saccharides means you take monosaccharides also. Okay, somewhere they use the term saccharide, somewhere they use saccharides means then question mark. Some people use the word TIRE, some people may use the word TYRE. So then the T question mark RE means that problem will be solved. Okay, mouse trap result in both mouse trap and like that. Take a note of words used differently. If you go to European countries, if you are making some platform, composition means they use sidewalk, and European countries they use pavement. So these are some synonyms you use. if you are doing mobile device means mobile or cell phone or mobile phone or communication device. Okay. So beware of searching these specific terms, generate, generating, generated, all provide the same results. Sometimes if you search for this mouse, you end up with this mouse. So mosquito, insect, there are so many things. The search is a game of, just like it's a, even though we think that we do beautiful search, but some from German, some journal, you might have missed that one. That is many times, nobody can do the 100% search. At least with best of your knowledge, you do the search. You think that I have done a beautiful search, but someone will say that, sir, it's already available in Belgium, this journal, like that. People may say. So repeat and you do the search, repeat the search and try multiple databases. Okay. This is the Google patents. If you do the search in Google patent, there is related inventions will display. Just you click, you will get all the information. So these are the things about patents. The patent is nowadays it becomes some people use this as a business also. That's the reason why the Sun magazine, they say that the patent people, they called us patent terrorist. Before that I thought the terrorist means they take the gun and shoot. But what these patent terrorists will do is, if suppose the Microsoft is, they have found out some beautiful invention, tomorrow they are going to introduce the product in the market, some other company, they don't know what exactly their invention. They roughly they know about their invention, they file a patent. They file a patent just before the entry into the market, they file a case in the court and says that this is my invention. Whenever the court hearing comes, definitely, for example, the Microsoft will win. He will never win. But his ultimate aim is not to win. Just delay the period. Just delay the period for 6 months. Even like India, there also if anything goes to the court, what happens? Minimum 6 months. 6 months delay, they will lose lot of money. So the term called outside settlement. Even for patent, this thing infringements also, so many outside settlements nowadays it's happening. The term called outside settlement, they demand huge money, such a huge money. Otherwise, they will not allow you to enter into the market. Such a huge money they demand. These type of companies are there. Their only job is stop the come into the market. So they make lots of, these people are coined as patent terrorist. Okay, like that. When we talk about patent, immediately the people ask me the question, sir, what happened to neem, turmeric? Of course, neem is our product. American Patent Office granted patent for neem, immediately come to our notice. So Indian government, they filed the case and says that this is our traditional knowledge. This is our traditional knowledge with all the evidences, the culvert and the evidences, all these evidences we produced. Then finally the patent revoked. Okay, like that, the turmeric also. Some people got the patent for turmeric and finally we objected, Government of India objected. Then after that what happened? They revoked the patent and finally we came to know that the applicant and inventors are not Americans, Indians who settled in America, they filed the patent in US. Like that, that Basmati also. The 20 claims they filed patent in US Patent Office and they granted. Then we objected and finally nearly around 14 claims they deleted. They allowed only the 6 claims. They given some reason, says that this has the small, the Texmati like, it grows only in the Texas climate. It's the hottest climate. The extreme hot and extreme cold will come. So these are all the things. There are many things about this patent infringement is always there. So another 10. So the people, if you have any questions, you can ask questions. Otherwise, if one way of talking, definitely that will be boring. It's taking class is very easy, but listening is difficult. And after lunch hour, if you ask me to listen a lecture for more than an hour, definitely I will sleep. But here nobody slept. Thanks.
Hi sir, thank you for explaining all those things. So can you differ what is a copyright and what is a patent?
Yeah, copyright and patent is the patent in the sense if you are inventing something, some technical features involved, that is exactly the patents. And copyright in the sense if you are writing a book. For example, if you are some thermodynamic concepts, if you are writing a new book called, then book you can go for a copyright, or making a music composition, and these are comes under copyright.
Sir, and one more thing, why patents are only for 20 years? Why? Why patents are filed only 20 years initially?
See, after 20 years the value will go. 20 years is more than sufficient. If suppose today you are doing some technology like something, you are inventing some cell phone. Today you are inventing some cell phone. After 20 years, the same cell phone, do you think the same cell phone may be available? The technology will go. Nobody will ask for that particular. So whenever I talk about cell phone, immediately the thing comes into me. One inventor from Madurai, his name is Ram Kumar. He come to us. He got a patent for that cell phone. Cell phone means in the cell phone there is double slot. The previously only one slot was there, only one SIM slot. Now there is two SIM slot were there. The inventor is one Mr.M. Ram, he comes from Madurai district, and he got a patent. And what we do, when I get a patent, and then I make one frame and keep it in my home, and I will publish in Facebook, WhatsApp and everything, status, Twitter, I say that I am the inventor and everybody congratulate me. That's usually we do. What he did is, very next day he go to customs, airport customs and naval yard customs, and says that the double slot patent granted to me. So whatever the cell phone comes from any countries without my permission should not come inside the country India. Like that he said. And very next day the customs official called us. Sir, one person has says that, and he says that something called a patent, sir. Because there is no awareness for even customs officers also. Yes, sir, that's what the patent law says. You are not supposed to allow the cell phones. And after 2 days, all the cell phones from Korea and Japan dumped in airport. There is no place. And very next day, the Joint Commissioner Customs comes to our office. Then we given all the guidelines. But our people may not aware about that patents, but the real inventors, the Korean inventors or Japanese, they know about what is patent. Immediately they call the inventor, what do you want? I don't want my phone dumped in custom yard. Then immediately they ask, please allow me. And he asked 35 rupees per piece. He is very ordinary person. He asked 35 rupees per piece. So very next day he allowed, and within a year time he makes crores of money. So he make one beautiful company in Mylapore, one company, he has one general manager, this, that, good office. He made such a, and after that his friend advised him, why you are asking only 35 rupees? You ask for 100 rupees. Then he asked 100 rupees. That also they agreed. and finally they don't know what to do, how to end up this matter. And finally in section 84 and 64 our act says that if a person, he is making some product means he has some research industry there and something like and some affordable price he has to give, and there are so many things are there. So using this one, then it goes to IPAB, finally he lost the case. But before that he makes lots of money, that's different story. So in that one, in allied stories, there is so many stories are there. So very ordinary person, how the patent makes the ordinary person to grow high. That's what I wanted to say this story. Yeah, you want to ask some questions?
Sir,
yeah.
I have a question. Thank you, sir. That was a really good explanation of how patents works. I actually have a question like, if at all you manufacture a biomaterial. Okay?
Manufacturer?
Biomaterial. Biomaterial.
Okay.
I am synthesizing a biomaterial, and there is already few papers and patents published that they are using a certain polymer or certain substances with which the biomaterial has been synthesized. The only thing I am doing is I am just changing the methodology and the polymer used. Can this technology, and it has all the properties which is required for that specific material, can this be patented as well?
Yeah, method of manufacturing is, for example, one mango tree, one mango is there. If you climb up high and take a mango, and if you use or 31 you can cut it, or one person with one bucket, it will not fall down. So the method of plugging mango is also patentable. Not only the product is patentable, the method is patentable, system is patentable, the procedure to arrive the concept is patentable. So don't think that only one patent for that one. These are different, these things. I can do this in cheaper way. I can do this in simple steps. You can go for it.
And one more question, sir. When you told about the train example, where they have fitted a fan,
yes.
If at all the person demonstrates that in a real time that with the fan the train is moving, can that be patented, or like?
He cannot demonstrate. It's not possible. He cannot demonstrate because output energy cannot be more than input energy. It is complete violation of second law of the Kelvin-Planck statement. Okay, it's not at all possible. If you say like that, if you demonstrate, then it's history breaks. It's not at all possible.
Is it necessary to demonstrate or show a real-time example for every time?
Yeah, if a doubt comes, definitely we will inspect. Some people is just like that, they say that I am getting this much percentage, means if a doubt comes, so we have plenty of applications, but in the rule 16 of Patent Act says that if you ask you to demonstrate or if you ask you to produce a sample, means you need to do.
Right. So the doubt which I have is something different. See, there are multiple products which are already available in the market. So I assemble them and design it to suit a particular application, which has never been done before. Is this patentable?
Yes, yes. The way of assembling. In this manner, if I assemble, I can get better output, like that you claim. Not only, that's what I said, not only product. It's a way of doing that particular work.
And for
procedure also patentable.
For approaching for this kind of patents, is it mandate like I have to do a working model or my simulation will find?
No, that we cannot give most of the things we cannot give a working model. Okay, some of the things for the system and procedure, how do you show that working model? Just you can make one in the app, you can do something and demonstrate. I mean, that's not required.
Your talk was very informative. So my question is, if I got a patent for my work in India, will it valid in some other country?
No, it's not. There is nothing like if someone is saying that I got an international patent, means it's not right. If suppose you file a patent in India and tomorrow someone else, same patent, someone else file a patent in US, means US examiner will not grant the patent because it is already available in India. Okay, but I ask you to file a patent in other countries. Why? Because one invention, in world only one invention is available. The reason behind is you cannot do any marketing or licensing rights in other countries. So I ask you to file a patent again in US quoting Indian priority date. Okay, then only you can do the marketing rights. Nobody else will get a patent in US. But you want to do some marketing or do some royalty or licensing means in this scenario the patent is required.
So, next question is, making unique design on material is patentable or not?
Making?
Unique design on materials.
Yeah, design, that is called, one more thing is called in intellectual property rights, design rights is there. That is only the aesthetic appearance. Aesthetic appearance, you can go for design.
I mean shapes.
Yeah, shapes. As such, that is 6 photographs is more than sufficient. Top view, front view, side view. That 6 photographs, if you file that one, only the design office available in Calcutta. If you file a design applications in Chennai Patent Office, we will forward your application to Calcutta and the people will examine this one, and design application within 6 months time you will get. Only the aesthetic appearance, that is design is different, patent is different. Both are entirely different, no technical matter involved in design. Here it is technical matter involved. There it is photographic, the aesthetic appearance. Right?
For example, chair, the shape of the chair is
shape of the chair, you can go. This chair shape, many people got design for this particular chair.
It's okay, thank you, sir.
Design is different. Some people say that, sir, I got a design patent. There is nothing like design patent. Patent is different, design is different. Patent is technical matter involved. Design is only the photographs. Someone says that design patent means that's wrong. Design is different, patent is different. And some people says that in Australia that is called innovative patent. If you file something, they don't check anything novelty or inventive stuff. Just stamp and give. And sir, I got a patent in Australia. That's not a valid these things. Okay, there is 2 things are there. One is called standard patent, other one is called innovative patent. And some patent comes, I think your deputy director, the Kumarasan sir, once he shown something, someone's biodata, he says that some patent called innovative patent. Then I told him that, sir, this is not the valid patent. In 2 months time people will give that one. That's not valid. It's not standard patent. Like that I given some advice.
Sir, good afternoon, sir.
Yeah.
Sir, I want to know about the procedure to whom to approach to file the patent. I mean the administrative work related to this.
The patent filing procedure is very simple, madam. One thing is, there is record forms are there. It's just like that you can fill the forms, the form 1, form 9, form 18 you can fill. And form 2 is called the complete specification. The complete specification, it's not like, what can I say, it's a technical matter. It's a techno-legal language. First one is the field of your application and background of the invention. What are all the patents so far filed before and how your invention is improved from the previous one, that you need to mention, and the statement of invention, summary of invention, detailed description, and most important part in patent is claims. So, where you are characterizing your product, that is very, very important. And then abstract and finally drawings. This, if you go to Google Patents, that sample of writing, this thing is available.
And one more thing, Puvisar Kuriyid patti I want to know about it.
Puvisar Kuriyid, it's nothing but geographical indication.
Yes.
Geographical indication is nothing but, for example, ஒரு saree பார்க்குறீங்க, காஞ்சிபுரம் saree, அப்படின்னு சொன்னா எல்லாரும் வாங்குவோம். So, whether I can sell some saree in the name of Kanjipuram saree, I cannot. Some registered society in Kanjipuram already registered in our office, they only can produce and sell Kanjipuram sarees.
It is also a patent?
No, it's called in intellectual property rights, there is so many divisions are there. Patents, designs, trademarks, and one more thing is called geographical indication. The Puvisar Kuriyidங்கிறது வந்து geographical indication. For example, oranges, Nagpur oranges na ஒரு name, Madura Mallikku ஒரு இது இருக்குது, Tanjore plates. So, like that, the Tanjavur Talayati பொம்மை, இதெல்லாம் பார்த்தா the specific value, the place has some value, right? In do you think which state got maximum GI? Number 1 is Karnataka, next one is Tamil Nadu. Okay, this is the GI is completely different from patent. It's a geographical origin, just for geographical origin.
Thank you so much, sir.
Hello, sir. Is genetically modified organisms are patentable or not?
GMO. No, GMO, there is so many restrictions are there. So genetically modified means already some countries have some specific, that's why I told that Angelina Jolie story, that genes has a specific this thing, and genetically modified. Now the thing is relaxed now. Okay, thanks. Thank you very much for patient hearing. If you have any doubt, you feel free to contact me. Our office is very much nearby, just 2 kilometers away. Okay, come and meet me. Any help, definitely I will help you, right?
Thank you, sir.
Thanks.
Thank you for the informative speech. See, from this session, you would have got an idea. Just publishing paper and getting the degree is not enough. You have to do patent, and you should get the patent. That is very important.